Drug cases can be beat. Here in San Diego, we deal with a lot of drug cases, right? The proximity to the border, substance abuse issues on the rise, the combination of mental health and everything that goes with it. But these are cases with the right effective strategy, with the right fact pattern, and equally, if not more importantly, with the right attorney by your side, can get beat. And there's a lot of hope no matter how much drugs you were found with, whether we're dealing with methamphetamine, whether we're dealing with heroin, cocaine, or even fentanyl. In this video, we're going to explore many things. We're going to explore how, in fact, you could beat a drug case. We're going to talk about the differences between simple possession as a misdemeanor and possession for sale or transportation as a non-reducible felony. We're also going to talk about things you could do to keep certain pieces of evidence out, that the prosecutor cannot use it against you. We're also going to talk about how a case can be filed in different jurisdictions, state court, federal court, what that looks like, how the case is filed, who's filing it, where is it filed, how it could all have an impact on your case. And finally, we're going to talk about some implications, collateral consequences, stuff like immigration consequences generally, professional licenses, and how all these things need to be taken into consideration when discussing a potential resolution. And we're also going to discuss the ways to work out a favorable resolution if going to trial, if litigating it through motions to suppress evidence is not necessarily in your best interest. Meaning we're going to talk about mitigation specifically as it relates to drug cases. First thing we really need to assess is how to beat a drug case. Drug cases can be filed as simple possession, almost exclusively will be a misdemeanor. Probably won't involve a whole lot of jail time, if jail time at all. Or if it's filed as possession for sale or transportation in state or federal court, you are likely facing a significant jail sentence if you're convicted. So the first step is trying to differentiate between where is the line between possession and possession for sale. Well, a lot of that will depend on what actual drug we're dealing with, the value of that drug, the amount of drugs you've alleged to have possessed, and also what other indicators there are that may have been something possessed for more than your personal use. So we'll explore the situations where you may have, a decent amount of drugs on you, but without any indicia of sales. What that means in English is you're not having, pay and owe sheets. You're not bagging it up. You're not having stuff on your cell phone that talks about bad evidence, about buying drugs, about selling drugs, about redistributing drugs. All of those things may wind up just being a simple possession case if you don't have those other pieces of evidence. And even if you do, there are ways to beat those cases. You could be found with a significant amount of drugs in your car, but there's something known as a motion to suppress evidence. Basically, what you're alleging is that how the cops got into possession of that evidence was through something done illegally. Say, for example, you get pulled over and the cops want to get in your car. Well, they need a couple of things in order to search your car. They need consent or they need a warrant. Now, there are a lot of exceptions to the warrant requirement in addition to consent, but let them figure that out. So if you don't give consent for them to search your car, they may need a warrant or they may need to make this plain view argument and all these types of things. But if you give the cops consent to search your car, whatever they find is fair game. You may not have, in all likelihood, a viable defense, but let's say you do. You could be successful in keeping out certain pieces of evidence. So even if you keep out maybe the search of your cell phone, maybe that was done improperly. Now what that means is the prosecutor can no longer use that evidence against you. You've effectively weakened their case, and you make it more likely that you have a good opportunity to actually beat these charges, no matter how much drugs we're dealing with, no matter where the drugs were found, no matter what type of drug was actually found. Now, moving on, it's important really to assess the difference between a simple possession and possession for sale and what that looks like from a penalty perspective. A simple possession is almost exclusively going to be a misdemeanor. If you're convicted, you'll have a misdemeanor conviction on your record. There may be some programs that you could do to get this set aside, get your arrest record or your conviction dismissed, purged from your record, whatever the case may be. But the biggest difference is you will go from simple possession as a misdemeanor to possession for sale. That is a non-reducible felony, meaning that that conviction cannot ever be reduced to a misdemeanor. You'll be stuck with that felony without the ability to get it reduced to a lesser offense. So there's really no quantifiable line the way there might be like in a DUI if you're 0.08 or higher blood alcohol content, or in a theft case if you've exceeded a certain threshold in amount of loss. Drug cases, possession for sale, there could be people that could possess multiple grams of a drug. It could be for personal use. There could be people that could be selling or possessing for sale just a fraction of that. It is all case specific. Even more reason why you need to surround yourself and hire an experienced criminal defense attorney who actually knows what they're doing and who's handled drug cases at a high level than the case that you may be going to that attorney for. Now, another big difference in drug cases is where the case is going to be prosecuted. Specifically in the Southern District of California, here in San Diego, whether it's going to be prosecuted in state court or in federal court. There is a big difference, and there's a lot more to it other than what we're calling the judge, where the courthouse is located. Almost exclusively, you would rather your case be prosecuted in state court. There are less mandatory minimums you need to worry about as far as mandatory minimum sentencing. There's more flexibility as it comes to sentencing. You're not necessarily dealing with the federal prosecutor who will not be as lenient or will not be as willing to negotiate the case the way a district attorney may be, especially if there are some issues in your case. It will also affect where you serve your time. In federal court, it could be with the Bureau of Prisons. In state court, it could be more likely than not in county jail, whether that's a quote-unquote prison sentence for more than a year or whether you're spending your time in local custody and getting probation. Many differences. There's really no rhyme or reason to it for the most part, whether you wind up in state or federal court. No matter where you find yourself, you better make sure you have the right defense attorney, the right team with there and for you each step of the way. Now I want to talk about two key terms we hear in many cases, particularly in drug cases: mitigation and collateral consequences. Okay, what does that really mean in English? Well, first, mitigation is really a type of evidence that you could present in defense of a case. There's evidence as far as factual evidence, eyewitnesses, concrete evidence, whether it's you're disputing whether a drug was a drug. And then there's mitigation evidence, which never gets before a jury in a case like this involving drug crimes, but is super, super valuable if and when there comes a time to where you want to resolve the case, whether with a negotiated deal with the district attorney or whether you're going to the court and asking for a lenient sentence. So what type of mitigation evidence about you, your background, what you stand for, where would you be if it weren't for this case, and what your hopes and dreams are, what real relevance does it have? Well, it's really important, especially if done the right way, because it differentiates you from anyone and everyone else who may be in a similar position with a similar type of drug, possessed a certain way, with a similar amount, similar weight, all those things, to ensure that you and your law firm and the defense attorney with and for you at each step of the way is doing anything and everything possible to get you as good, if not a better outcome than anyone else possible. So if you have a substance abuse treatment issue, you may want to go into a program, whether it's residential, whether it's an outpatient program, whether you just want to go to some AA or NA meetings. Let's establish a plan together. Let's map out how to get where you are now and where you want to go, and how your criminal defense attorney by your side can help you get there to ensure you get the best outcome possible. Now, another term we use, and attorneys use too often without really explaining it, are collateral consequences. Collateral consequences in English basically means stuff outside the courtroom that's going to be affected by your conviction or the charges inside a courtroom. So a lot of times in drug cases, we'll see people that may not be United States citizens. Maybe they're legal permanent residents. Maybe they're here on a visa, work or a school visa, or quite frankly, sometimes they may not have standing to be in the country legally to begin with. So you need to be mindful if you or a loved one find yourself in this situation, not just to jump at the best deal possible, just to get out of jail or just to, put an end to it so you know what things are going to be and what the outcome is going to be. You need to be aware of collateral consequences about how this charge, how this conviction could affect you not just today, not just tomorrow, next week, next month, next year, and in many instances for the rest of your life as it applies to work, school, and quite frankly, your ability to stay in this country. Another collateral consequence that you, and more importantly, your attorney needs to be aware of and should be thinking about from the early stages in representing you if you have any professional licenses. Let's say you're a real estate professional. Let's say you're a lawyer. Let's say you're a doctor or a nurse. We are not immune from substance abuse issues. Just because you're a professional does not make you immune from drug charges. In fact, sometimes the converse is true. You see a lot of people with professional licenses who went to fancy schools, who have great jobs, get caught up in high-level drug cases for a number of reasons. So your attorney and you need to be mindful. Hey, how's this case going to affect my ability to still be a lawyer? How's this case going to affect my ability to be a doctor? So on and so forth. So you make sure that you're taking the best outcome if you are going to negotiate a deal with the prosecutor or the court, not just to protect your freedom, but to protect your future each and every day for the rest of your life. So today we covered a lot of things as it relates to drug cases. We talked about how a case could be charged. We talked about ways you could beat a case. We talked about the differences between personal use and possession for sale, what that looks like on the front end of the system, what that looks like on the back end of the system. And we talked about collateral consequences, professional licenses that could be affected by a drug case, especially felonies involving possession or distribution of these controlled substances. We rattled off a couple of controlled substances about cases we normally see here in Southern California, and we also talked about the differences between state and federal prosecution, what that looks like aside from just where your case is prosecuted, who it's prosecuted by, what your possible consequences are, what sentencing flexibility a judge or prosecutor may have, what you get, where you serve your time, if in fact that's in play. And we also talked about things your defense team can do to ensure that you get as good, if not a better outcome than anyone possible in your situation through the effective use of mitigation evidence. What is essential to know about drug cases is that in many ways, they are much like any other criminal defense case with the basic principles. You do not want to talk to the police if you are questioned about whether it's personal use or sale. You do not want to do the cop's job for them. You don't want to give consent to search. Politely decline. Ask them to go get a warrant. If they show you a valid warrant, you cooperate. You don't want to make it any easier, but you also don't want to be difficult and rude and abrasive in the process. That's not going to be a good look down the road. And at the end of the day, you want to make sure whether you're facing a misdemeanor charge or whether you're facing the most serious drug felony charges imaginable, that you do what you can to protect your freedom and protect your future. And you do that by understanding first and foremost what your rights are and go out there and get yourself the right criminal defense law firm who knows how to handle these types of cases at a high level. So if you found this video useful, more than anything we could ask is that you like it, you share it to someone who may find this information valuable and helpful in some of their most difficult times, especially those who are dealing with drug cases.